Dean. So Dean, I'm just going to let you go ahead and get started. I'll just let everyone know that we'll keep you on mute. Please ask questions in the chat box and we'll address those as they come up. And at the end, we'll leave time for open dialogue for question and answers. And thank you so much for attending. Dean, go ahead.
Hi, my name is Dean Bennett. I'm a lawyer at Holland Hart here in Boise in the Zions Bank building. I've been with Holland Hart for 13 years now. My practice focuses on labor and employment issues, and then I'm also a commercial litigator. And when I say that, I mean any kind of dispute that you would have before an agency or a court, I handle those. But for purposes of today, I do a lot of employment counseling, and there's employment law for businesses. There are a million topics we could cover. I try to pick a couple topics today that I think are pretty relevant for right now. And most of the questions I'm getting are COVID related. Shocker, shocker. It's on the front of everyone's mind. And so I'll talk about some of the agencies and the guidance and where we're at with newly published guidance, non-binding guidance, binding guidance, and how employers are navigating that and the type of questions I'm seeing, and hopefully address some of those issues for you. And then the other topic in my practice that's employment law and commercial litigation is protection of trade secrets, confidential and proprietary information. And specifically in Idaho, there's some ways that I think employers can protect that information through the use of non-competes. What we're seeing, and it has hit my family, my wife just quit her job on Thursday to pursue some other things. And I think during the pandemic, people are evaluating what they want their career path to do or to be, where they want to be employed and looking for other opportunities. Obviously, we have a pretty big shortage on labor right now, and I think that's in service areas a lot. So I'll talk about some of those strategies that employers can take to protect their information as you're either hiring new folks or as people are departing your organization and potentially going to a competitor. Biggest question on COVID right now that we get, to vax or not to vax, and whether you should have a policy about vaccinations, whether you should have a mandatory policy, whether it should be elective, whether you can provide incentives, what incentives can you provide. And as we go through this presentation, I'm going to try to hit a bunch of high points, but I would like to say that so many of these things are very factual, and every situation is a little bit different. So I'm going to provide the best guidance, kind of high level guidance I can, but I do think it's important to reach out to your HR professional or reach out to a labor and employment lawyer to help navigate these issues because, again, it's very fact intensive. So basically, throughout the pandemic, we've been looking to the alphabet soup of federal organizations to help identify what the standard of care is or best practices are. And today I'll talk about OSHA, which is protecting employees in the workspace. I'll talk about the CDC Guidance. And if anyone watches the national news, you see the director of the CDC on there, it seems like nightly. And there's been guidance, and guidance would come out and there would be great FAQs and some formal interim guidance, and then it would change or it would be modified. So what I'm going to try to do today is give you a lay of the land of where we currently are. And then the organization, the EEOC, and locally here, the Idaho Human Rights Commission, governs discrimination in the workplace and disability discrimination in the workplace and retaliation. And a lot of the times you'll see the EEOC will direct people to the CDC, and then the CDC will direct someone to the FDA and back and forth. So the guidance isn't terribly clear. And when you get one of these fact-intensive questions, the place to go is to go look at this guidance to form the standard of care that an employer has to navigate these issues. So we'll be talking about some of those. On top of the federal guidance, which I think Idaho has been pretty good at deferring to, but if you have employees in other states, there are local and state specific restrictions and guidance that exist that may be more restrictive than what the feds are saying. And that you probably have heard in the news, for example, Los Angeles and some local areas have decided that there should be more restrictive guidance with regard to social distancing and face masking and those kind of things, whether you're vaccinated or not. I think the governor of Illinois came out and said the same thing, I think yesterday. So when we're going through this, be aware that there could be state or local requirements that are more restrictive than the general federal guidance. Also, I've had a number of healthcare employers. I'm not sure if we have anybody on the line who's a healthcare employer, but a lot of healthcare employers have been looking to the non-healthcare guidance and coming to me and saying, well, here's what we're going to do. And I have to say, well, time out. Things are a little bit different for healthcare employers than they are for the rest of the industry. So I'm not going to touch on much of the healthcare stuff other than say some differences that exist. So just bear that in mind. Turning to the CDC guidance, and this is really good news for everybody and really welcomed. I know that I currently manage our Boise office here. We have 83 people in our office, and we've had difficulties navigating all the things that you're supposed to do: the hand sanitizers, the disinfecting, the signs, the exits, the entries, one ways, all of that kind of stuff. And I know that there's a bunch of fatigue for our essential workers that have been here and for a number of the lawyers that I work with. But the current CDC guidance says for fully vaccinated individuals, you can resume activities without wearing a mask and without social distancing, again, subject to local laws. You can refrain from quarantining following an exposure if you're asymptomatic. So if you have an employee that has a spouse that tested positive for COVID, they're not required to quarantine anymore. They can come back to work. And I know a lot of employers and best practices, if you had folks visiting your facility, you would request them to sign a health authorization or acknowledgement that they didn't have symptoms, and you may take their temperature. And for fully vaccinated people, the CDC says you can back off on those types of restrictions. I've had some questions on what does fully vaccinated mean. I think it's pretty well known now that if you receive the Pfizer or Moderna vaccines and you've received both doses and you wait 2 weeks, and that 2-week period is important, you might have your vaccination card and you got both doses of the vaccine, or for the Johnson & Johnson, the single vaccine, but you need to wait that 2-week period before you're considered fully vaccinated and you can back off of some of the restrictions. On the healthcare side of things, if you're in a healthcare facility, fully vaccinated people still need to socially distance. They still need to wear PPE, and there's some other requirements there. And the CDC does a pretty good job of laying out those standards on a separate page. So if that applies to you, make sure you're following that guidance. For unvaccinated workers, largely unchanged. And I think we are all tired of seeing these restrictions, and we know how to implement them. You need to wear a face covering. You need to socially distance. You need to tell your folks if you experience symptoms or test positive, you need to isolate. If you have close contact, which we'll talk about the definition of close contact in a bit, you need to quarantine. Although the virus is spread in the air more and less by touch. I don't know if you guys remember at the beginning of the pandemic, I think there was some CDC guidance that said when you bring your groceries home, leave them in your garage for a period, disinfect them with wipes, and no one could find any disinfecting wipes. But a lot of that has been mitigated. We're not doing those kind of things anymore, but in a workspace, you should still have someone in your office for unvaccinated workers who's going to touch the high touch areas, the doorknobs, the shared microwave, the refrigerator, the coffee pot, those kind of things. So as an employer, do the things that you've been doing for unvaccinated people. Encourage them to stay at home, conduct those health screenings, or ask employees to still acknowledge that they don't have symptoms, that they don't have a fever, and continue to clean and disinfect the office space as much as you can. Whether you have an outside vendor that comes in and does additional disinfecting, or you have someone assigned in your office to go around a couple times a day and get those high touch areas. So if you have a positive or symptomatic case in the workplace, again, this is pretty basic stuff. You need to instruct that individual to isolate. We'll talk about those periods. You're going to clean and disinfect. The CDC does have some guidance. I've had some questions on what does clean and disinfect mean? When should we do it? How should we do it? Basically, if you have an employee that's been in a high touch area recently, the guidance still is wait a period of time, several hours before going in there, to make sure that any aerosol portions of the COVID virus have quelled or settled, and then go in and do a deep cleaning of the area. If a person comes in, if the person was in the office on a Friday and they don't test positive until the next Wednesday and they notify you, if there's a 3-day period in there, there's no need to do additional cleaning or disinfecting. Close contact, and this has changed a bunch over the time of the pandemic. But what the current guidance is, if you're within 6 feet of a symptomatic person for 15 minutes over a 24-hour period, that constitutes a close contact. And you want to do a 2-day look back period. What's important to remember here is if you have someone that has identified as having COVID, because of privacy concerns and direction from the EEOC, you can't tell employees down the hall, hey, John Smith over in office 4 tested positive for COVID. You got to keep the identity of the person confidential. And this has proved very challenging for employers. The way that we've mostly been able to navigate this is you can ask the employee who tested positive for COVID, can we disclose your identity? Basically, everyone's going to know if John Smith isn't down the hall anymore, that he's probably the person. And they can make whatever assumptions that they want, but the employer can't affirmatively disclose that without authorization from that employee. So I'd say ask the employee. It's been our experience that you ask employees, people have been pretty good about allowing the employer to disclose. Quarantine and isolation periods, again, this has changed a bunch over time, but the current periods are if you have a positive case or symptomatic there, and this is a conjunctive, you need to do all 3 of these things under the CDC guidance. You need to wait at least 10 days since the symptoms first appeared. You need to wait 24 hours for the person to have no fever without fever reducing medication, and the other symptoms of COVID, difficulty breathing, loss of smell or taste have gone away. On the, there we go. On the quarantine side, and this is for people that have been exposed at close contact, CDC recommends 14 days, but if allowed by your local health department, and I think we would qualify for that here in Idaho, you can go 10 days without a test, or you can go 7 days with a negative test, but the test must have occurred 5 days or later after you've been exposed. So that kind of creates a kind of a problem. I know test results come back a little bit faster, but basically if you're testing on day 5, you can get your results back in a couple days, and maybe that shrinks your window down from 10 days to 7. You do not need to quarantine again if you're fully vaccinated, meaning you've received the appropriate dose, 1 or 2, and if you've waited the 2 weeks. And another portion of the CDC guidance is relatively new. If you've been previously diagnosed with COVID-19, I believe the guidance says within the last 90 days, and that you've been exposed, you also don't have to quarantine. It took OSHA a long time to put out some new guidance. Here we are in month 15, 16 of the pandemic. They updated their guidance on June 10th, 2021 of this year. And there's non-binding guidance for general businesses. If you're in the healthcare sphere, there's some binding guidance. And you're subject to the emergency temporary standard, or what's been called the ETS. I'm not going to cover that in detail today, but it's significantly more onerous. On the, I'm going to call it the business side instead of the healthcare. The focus of the OSHA guidance, much like the CDC, is on unvaccinated people and other people that are at-risk employees. And at-risk employees could be those that are immunocompromised, a recent transplant, something along those lines. But basically, fully vaccinated workers, the employer doesn't have to take too much care for those people. For at-risk folks, the guidance says it encourages the employers to engage with those workers to determine the best way to implement mitigation measures and to take precautions to protect those that are more vulnerable. Much like the CDC guidance, a COVID-19 program, and this is non-binding, but OSHA and CDC does form the standard of care. So these are things that you should consider doing. And some of these are new, paid time off for employees to get vaccinated. That's something that you should seriously consider. I think vaccinations are widely available at pharmacies, at hospitals. I don't think it should be a problem for your folks to get the vaccine, but you should consider giving them time off to get that done if that's something they want to do. And then the other things, instruct people to stay at home, continue with physical distancing for those unvaccinated, those darn face masks that are very politicized, still need to be worn. Suggests that unvaccinated guests and customers wear face coverings. I don't think it's hard to mandate it. And frankly, I have a couple cases going on right now where there's large retailers who have required customers to come in to wear masks and they refuse to give service. I think you're probably within your rights to do so. I mean, if you can say no shoes, no shirt, no service, I'm pretty sure you can say, if you don't wear a face covering, we want to protect our employees and our other customers. You need to wear a face mask, but be aware that there are a number of lawsuits pending across the country, and some even here in Idaho, where pretty brazen folks have said, I have some kind of constitutional right to decide whether to wear a face mask or not. And if you make it completely mandatory, you might be buying yourself a lawsuit. Ultimately, I think you'd probably prevail in being able to require face masks, but there definitely is some expense in hiring a lawyer and some business disruption to the business to go through the litigation process. OSHA is also pretty high on ventilation systems, and this is for the kind of places, manufacturing, food process, high volume retail and grocery. They want you to do some things to make sure that you have appropriate ventilation systems. They still recommend to stagger break times and departure and arrival times if you have a whole bunch of employees going onto the floor at some point. It's important still to have the floor markings and posters and reminders to wash your hands and use hand sanitizer and to have those resources available. This is not rocket science stuff. I think employers have been very good about doing this, but now that this has been reduced to writing, it is going to inform the standard of care. And if an employer didn't do these types of things and there was some outbreak in the workspace, the employer could have liability. So now we get to the EEOC guidance and mandatory vaccines. And frankly, I have written a host of memos. I've counseled a lot of employers on this question. The short answer is, with some caveats that I'll talk about, if you want to have a mandatory vaccine policy, you can do so long as you accommodate for disability under the ADA and the Rehabilitation Act and for religious beliefs under Title VII. Tougher question, should you adopt a mandatory vaccine policy? I think best practice most of the time is to probably say no. I think you're going to create some morale issues. You're going to create some political type issues in your workspace. And we'll talk about some ways to incentivize employees. You can mandate, it might buy you a whole host of issues, but I think educating your workforce on why a vaccine should be good, making sure they have the time and you give them the time to go get a vaccine if that's something they want to do is probably still something I'd recommend over a mandatory program. And then the much tougher question is, if you adopt a mandatory program and you have an employee that says, I'm not going to do it, are you willing to take the step off the ledge and terminate that employee? And we'll talk about some lawsuits that have been filed in that regard, but that can create some business disruption and certainly some headache. Whether it's a mandatory policy or it's or your policies for how you treat your workers in your workspace, the employer necessarily needs to know, are you vaccinated or are you not vaccinated? And I have a lot of questions. Can I ask my workforce, are you vaccinated? Can I require them to provide proof? And the EEOC has said yes. You can ask your employees the question, are you vaccinated? You can have them provide you a copy of their vaccination card, or you can have them sign a certification that says I'm vaccinated. What you can't ask is, why aren't you vaccinated? Or ask for any medical type information or disability related information, because unless you can meet a very heightened standard, which we'll talk about in a second. Again, the information should be kept under lock and key. You should have someone who's responsible in your organization, probably HR or something, if they collect the information, whether it's automated on your system, or whether it's some kind of checklist or whatever process you want to do to keep that information, it should be kept like you would keep other ADA type information, so people can't see it. It's the status of vaccination status can't be released by the employer to the employees. And it's interesting when you look at the CDC guidance, they make all these distinctions between, oh, if you're unvaccinated, you have to do one thing. If you're vaccinated, you do the other. But they don't really address the issue of, well, how does the employer supposed to navigate these issues? You can collect the information, but you can't tell supervisors of vaccination, unvaccination status. But what you can tell supervisors is these people have these restrictions, whether that's because they've requested an accommodation or whether that's because they choose to wear a mask. You can tell supervisors what an employee has to do, distance or wear a mask or not, but you can't tell them whether the person's been vaccinated or not. So it creates a tough road for the employer to navigate. And for those employees that I know we all have dealt with them that cause employer headaches, this is a place where if you have some troublemaking employees or just want to make it difficult for you, they can make it difficult here. Employer provided vaccines. I haven't seen a bunch of this. I know there are some employers who have provided vaccines on campus. Here's where you must meet the higher standard, because if you require a vaccination and it's provided by you or an agent of you, meaning the employer, you must meet the standard that the vaccination is job related and consistent with business necessity. And that's what the language of the statute reads. And what that means is you, the employer, are going to have to show that if they don't get a vaccination, they pose a direct threat to the safety of the employee or others, people that may come into your organization. And that's a pretty high standard, as I'll talk about in a second. I don't think a lot of people are going this route. And just to be clear, if you have a purely voluntary employer provided vaccination process, you don't have to meet this direct threat standard because the employee doesn't have to disclose additional medical information as mandated by the employer. If you need to meet that direct threat analysis, you need to show a significant risk of substantial harm to health and safety. It can't be reduced or eliminated by reasonable accommodation. And if you think about the accommodations that someone would need, it may be the things that we've been doing. It would be remote work. It would be isolating, social distancing, mask wearing. So to show that an employee is going to cause a direct threat is going to be a difficult task for the employer to prove. So I think mandatory employer on-site vaccinations probably isn't the way to go. But frankly, I don't think that's a big deal because they're so widely available. If someone wants to get a vaccine, I think they can go into any pharmacy right now or get yourself on a list and get yourself a vaccine in reasonable time. I think the employer should give the employee some paid leave to do so. So then we're getting to what a lot of folks are dealing with right now are, okay, you have an employee that doesn't want to get a vaccine. If they don't want to get a vaccine because of a sincerely held religious belief, practice, or observance, the employer must accommodate that unless it's an undue burden. And under Title VII, it's a bit different. We'll talk about what undue burden means. But I think where some employers fall down is, what does a religious belief mean? And it doesn't mean that you have to be Catholic or you have to be a Seventh-day Adventist or you have to be some kind of organized religious belief that's mainstream and well-known. It protects moral or ethical beliefs that are sincerely held with the strength of traditional religious views. And that's a confusing standard. If someone says, I just don't like vaccines, or I don't think that the FDA has done a good job with the vaccine, that's not a sufficient basis to have a religious belief. But if they have a moral or ethical belief that's somehow similar to traditional religious view, then the employer should assume the validity of the belief and not deny the accommodation because they don't think it's an organized religious belief. So I wouldn't make the determination on whether you would accommodate someone for a religious belief on this basis. I think the better way to do it an accommodation for a religious belief, the standard is undue burden, but it's different than what we know under the ADA, the traditional undue burden analysis, which probably most of you are familiar with. Under Title VII, it's only more than a minimal cost or burden. So if there's some not nominal cost or burden, you can deny the accommodation. But again, practically, if someone's saying, I don't want to be vaccinated and I want to be accommodated, these are the type of things we're talking about. I mean, accommodation is just going to be, wear a mask, distance, reassignment, that could be more than a minimal cost or burden. A shift change could. Remote work, I think all of us have been allowing our employees to work remotely for the last 15 months. So if you're going to say that's somehow minimal, more than a minimal cost or burden, you're going to have documentation on how that is and be able to articulate to an agency or court why there is more than a minimal cost or burden. Basically, if someone has a religious belief, do your best to accommodate. On the disability side of things, it's even more difficult. There's no form ADA accommodation paperwork. I do have some forms that I provide to clients when they ask for it, but an employee must be able to identify the disability and request whatever accommodation they want. And this could even include fully vaccinated employees who are immunocompromised. But if they have a doctor, provide a reasonable basis for that they have a disability and that they want an accommodation, your duty as the employer is to engage in what's called the interactive process. And you want to document this. You don't want to have a telephone conversation back and forth between you and the employee about options. You want to document this and say, here are some reasonable accommodations we want to offer you. You working remotely from now until 2023, that's not a reasonable accommodation. We need to have people in the office and it's a benefit to the employer, and you can work through that with them. The undue burden analysis under the ADA, though, is not more than a minimal cost. It's significant difficulty or expense. And this is a pretty, frankly, it's a really high standard. Our federal courts in Idaho have said, even if an employee is all out of FMLA leave, a reasonable accommodation under the ADA might be providing that employee multiple weeks or multiple months of unpaid leave to be able to stay at home. And to say that's an undue burden is pretty difficult in the face of people who have been out of the office for the last 15 months. So why is it an undue financial burden here? So you're going to want to think about the cost and expense to use the employer, how you run your business, the effectiveness of them to be able to perform the essential functions of their job, how it may impact other employees, and then document all of that. And at the end of the day, what you want to do as an employer, if there's been an accommodation request by an employee, in the interactive process, I don't think you ever want to have an accommodation request come to you that you're silent about, and then you deny the accommodation. I think you always want to go back in the interactive process and provide a different reasonable accommodation. So there's something on the table, and then end the process. And if you're going to say, no, the accommodation isn't reasonable, at least you have something there on the table and you can show the court that you engaged in the interactive process. Pregnancy accommodations. Pregnancy is not considered a disability. Prenatal complications also generally aren't either, but you must treat pregnancy-related medical conditions like any other temporary medical condition. If you have someone that has a back pain or they're out for an ACL replacement or something, you need to, if you're going to accommodate those people, you need to accommodate pregnancy-related conditions in the same way. And aside from that, pregnant moms are very sympathetic plaintiffs in front of a jury and frankly, in front of a court. So consider an accommodation for these folks. It's temporary in nature. And it's just, you don't want to have someone on the opposite side of a V in a lawsuit. When I say V, you have the plaintiff versus the defendant. You don't want to have a sympathetic pregnant mom on the other side of the V. So consider these, talk to your HR consultant, talk to your lawyer, and make sure you're doing what you can for your pregnant people. So the other thing we get to is, okay, we can't mandate. Mandate's probably not the best route. There's some pitfalls with mandating and having to terminate people that reject getting a vaccination. They don't request an accommodation. They just say, I don't want to do it. That could lead to litigation. So what a lot of employers are doing is they're trying to incentivize by giving their employees some kind of carrot to get a vaccine. Initially, the EEOC said anything over $25 was coercive. And I think there's been some clarification now. That guidance was retracted. And so you see a number of large retailers, and it's well publicized, and there's lists on Google about all the things that people are doing. But giving some time off, giving Lyft rides, giving a stipend, giving $100 bonus to get a vaccination, doing a raffle prize like you see in Ohio. I think they did $1 million raffle prize for people that got vaccinated. These are generally okay to do. I think you do want to be careful that it's not such a huge incentive that people will feel coerced to go get a vaccination if they don't want to get one. But I think a lot of employers have found incentives for vaccinations, whether that's some additional PTO grant to use at a later time, or some kind of bonus that have been effective in getting some additional people in your workforce vaccinated. One thing to consider is if you're giving these bonuses to people who can't get a vaccination because of a disability or a religious accommodation, do you want to provide the incentive to them as well? And it's not very palatable for an employer to say, hey, I'll provide this bonus. If you get a vaccination, oh, you can't get one, well, I'll give you the bonus too. So you might consider conditioning it on maybe some education, or maybe taking some kind of online course or doing something about COVID, about the importance of social distancing and mask wearing, and then they could be eligible for the bonus. But again, there's a million different variations of how you can do these things. Before you put an incentive policy in place, talk to your HR professional or counsel. Where the EEOC guidance on coercion has clear traction is you can offer incentives, rewards, or penalties. But if we're back in that concept I talked about earlier, the direct threat concept, where an employer is providing a vaccine on site and mandating that their employees get it, then to do so, to get a vaccine, you have to answer certain medical questions. And that you could be by giving a big incentive, which requires people to disclose medical information to the employer, that can be coercion. So if you're going to provide incentive and provide on-site mandatory vaccines, I think you do want to stay under that $25 threshold, which frankly doesn't seem like much of an incentive to me. So whatever policy you pick, whether it's mandatory or whether it's incentivizing or allowing unvaccinated people to loosen restrictions, there's some things to think about. The carrot approach is, if you're fully vaccinated and you've got your vaccination card to HR, then you're free to ignore all the things that we all have not liked to do over the last 15 months. You don't have to wear a mask anymore. You don't have to socially distance. You can meet in conference rooms with your colleagues. You can have lunch in a conference room. You can go out to lunch, those kind of things. The stick is kind of the flip side of the coin. Anybody who refuses to provide documents must wear a mask. And so presentation style, and you know your workforce better than I do, but those are a couple things to think about. As far as enforcement, this is where it makes it pretty difficult, because how do you know who is vaccinated and not vaccinated when the employer can get the information, but it can't disseminate the information throughout your organization? And again, you can tell your supervisor, this person must wear a mask, this person doesn't need to wear a mask, but you can't tell them the reason why. i.e., you can't tell them this person's vaccinated and this person isn't vaccinated. Had a number of employers come up with what seems like a great concept. You know what, I'm just going to require anyone who's vaccinated to wear a green sticker on a name tag or a badge, and I'm going to require everyone who's not vaccinated to wear a red sticker so everyone knows. And if you're around someone with a red sticker, they should have a mask on. You shouldn't be without masks in a conference room. But if you try to implement a policy like that, you, the employer, are mandating the disclosure of whether you're vaccinated or not. So I don't think you can have that blatant of a policy. But what you can do, I don't think this is going to get much pushback. And I haven't seen any cases where this has been an issue. And again, a lot of the plaintiff's bar hasn't had an opportunity to bring these type of claims. But I think you could say, hey, if you want to wear a green sticker that indicates that you're vaccinated, your call. You can wear a green sticker. And if you do, you don't have to wear a mask. Everyone else, you need to wear a mask. And so that could be a way where you could kind of bridge that gap. And I think a lot of people, I mean, again, seems to be a few employees that are more difficult to deal with in whatever kind of employment sphere. The constant complainers, the people that just seem to make it hard for HR departments and supervisors, that make it hard for everyone. I think a lot of employees will happily volunteer. Yeah, I got my vaccination, I got my green sticker, I'm not going to wear a mask. So that's one way to navigate the issue, and I've seen a number of employers successfully do it. Just reviewing whatever policy you have, a couple high points. Include an explanation in your policy. Make it really clear that employee, if you have a disability related issue, needs accommodated, or a religious accommodation need, we will accommodate those requests. I think those should be in writing in the policy. I think you want to synthesize your vaccination policy with other employment policies. Hopefully you don't have some really onerous progressive discipline policy, because that creates a whole bunch of issues otherwise. But if you do have progressive discipline, or you have immediate reasons for termination, or you have performance improvement plans and why you put them on one person on a performance improvement plan and why you terminate an employee immediately, make sure that your vaccination policy syncs up with whatever your disciplinary policy is. Communicate the reasons in the policy for why you have the policy. If it's a mandatory policy, it can't be willy-nilly, oh, we just want people to be vaccinated. I think you want to say there's a reason we're doing this. We have a lot of, we're a retail place, third parties come into our space, we want to protect our customers. Let's say you're a grocer and you have a number of employees that are in close contact with customers. You want to say we want to protect our workforce. So articulate the reasons, whatever policy you have, articulate the reasons why you have the policy. Other thing to think about is a mandatory policy for all of your employees. You need to dig a little bit deeper. I mean, some employees that aren't around other employees, for them to be fully vaccinated might not make sense. So long as you're treating categories of employees similarly, you shouldn't have any discrimination risk, but you also want to make sure that there's a logical and reasonable basis why you would mandate someone in their role to have a vaccination. And then this is also really important. Some people will be vaccinated, and just because maybe they're immunocompromised, or maybe they just have had some loved ones that died of COVID and they want to decide to wear a mask and decide to socially distance. Or maybe people don't want to get a vaccination, but you should have something in the policy that instructs your employees. Some people may choose to wear a mask. That's their right. That's something that they can do. They shouldn't be retaliated against. They shouldn't be treated any differently. They shouldn't have any negative treatment at all. I think that's important. Some of those people who don't want to get vaccinated, who may be persecuted by other employees in your workspace for that, I think you want to make sure it's clear that vaccinated employees shouldn't treat those unvaccinated or those that decide to wear a face mask any different. Can you fire an employee for refusing to vaccinate? I think generally, at least the court cases we've seen so far and the guidance we've seen so far is, if you have a good policy in place with those 5 categories of things I just talked about, I think you can. You want to have, if you have a mandatory vaccination policy, you want to make sure that it's dialed in. You want to have your HR consultant or your lawyer review it before you haul off and fire someone, because that's when rubber really meets the road. There's been a number of lawsuits filed, and just some examples in North Carolina, Texas, New Mexico, and California are some notable ones that made national attention. And the basis for these lawsuits, among other things, and some of them are crazy, like by requiring me to wear a vaccine, you're treating people like they were in the Holocaust, and some pretty outrageous claims. But one common theme is the vaccinations that are in the US market right now are only approved by the FDA on an EUA, or emergency use authorization basis. And for the vaccination to be given, an employee needs to be informed of their ability to refuse or accept the vaccination. So they're saying, because the emergency use authorization allows me to deny it, you as an employer can't fire me for doing what I'm allowed to do by what the FDA says. And this alphabet soup of EEOC, OSHA, CDC, the EEOC points to the FDA points to the EEOC, and no one has really come to a conclusive determination on this. So we have seen lawsuits based on this emergency use authorization, but one that was very, very public, and in the media a lot was this Houston Methodist case. And that was a private hospital, and they required mandatory vaccinations. They had a policy in place, tens of thousands of employees, and everyone either got a vaccination or they refused to, or they asked for an accommodation, which the hospital gladly complied with, consistent with the law. But they had some holdouts that said, I don't want to get the vaccination. And the hospital fired them. And so the suit alleged under a whole bunch of things, including this EUA authorization language, that the employer should be liable to these employees for wrongful termination. And this is one court case, and it's in Texas, it's not in Idaho. But if you look at the court's decision, it was pretty terse and pretty concise, and said, look, Bridges is the named plaintiff, can choose to accept or refuse a COVID vaccination. However, if she refuses, she'll have to find work somewhere else. And knowing most of our Idaho courts, I think that likely could be, if you want to have a mandatory vaccination policy, the response that we get from the courts here. So a lot of things that you can do with vaccine or non-vaccine. Hopefully people are out there getting their vaccinations and things are going back to normal. But there is some good guidance out there, and myself or any other employment lawyer would help you navigate those issues. Turning to the second topic is protecting your trade secrets. Again, the reason I included this here on the tail end of COVID concepts and guidance is employees are on the move. People are changing jobs, remote work. We have lots of other employees from different states coming to Idaho. They're jumping from competitors. Competitors are offering maybe just a little bit higher salary, and they're moving. And you have those employees in your organization that know your secret sauce. They know why that you are able to compete in the market. They know your business plans. They know your contacts in the industry. And in Idaho, unlike some jurisdictions like California, for example, non-compete restrictions are enforceable. And I think if you don't have non-competes for people that can damage your organization, you're setting yourself up for someone to damage your organization and your legitimate business interests. So I'd say take the ability that you have under Idaho law to put non-competes in place. And I'm going to talk to you a little bit about best practices to do so. So quickly, just a quick precursor on the current law on non-competes, how to draft an enforceable non-compete, what happens if you have a non-compete in place and you actually have to take action on it. I'll speak briefly on some examples of whether you should use non-competes or not, and what one side of the coin looks like versus the other. And then know when you're hiring employees, they had a former employer who have the same concerns you do as an employer. What should you do when you hire employees to make sure that you're not setting yourself up for a lawsuit from the employee's former employer? So Idaho's non-compete law, and I would encourage you to take a look at it. You can do a Google search, and the legislature has a great website that has these statutes on it. It is a short code section. It's 44-2701 to 2704. It's only a few pages long, but basically it's the codification of what used to be the common law as articulated by the Idaho Supreme Court. And it's actually pretty easy to follow. It creates presumptions of enforceability in the employer's favor. So this is good. That's why I say Idaho is a good place to have non-competes in place, because there are presumptions that say, if you check these boxes, likely a court's going to enforce a non-compete. And then blue pencil is a term of art. It means if you put a restriction on an employee that's more restrictive than a court determines is needed to protect your legitimate business interests, the code section 2703 says the court shall modify the agreement to make the restriction only necessary to protect the legitimate business interests. So that means if you draft something that's too broad, so long as it's not crazy broad and beyond what's allowed by law, the court should give the employer the benefit of the doubt and put a reasonable restriction in place, which still means you can enforce your non-compete. So current law non-competes, the language of the statute, if it's reasonable and necessary to protect the legitimate business interests. And we'll talk about drafting some of these things, but that's good language to have in various sections of an agreement. The agreement has to be in writing, needs to be signed by the employee. They can do this either with a wet ink signature, or they can do it with a e-sign or through your system, so long as it's documented. Non-competes are only enforceable against key employees, and we'll talk about that definition, which is set out pretty clearly in the statute. I think a lot of employers consider key employees to only be their C-suite or only their really high-level, highly compensated folks. And I think under Idaho law, you can run those non-compete obligations down your organization a lot further than most employers think. Has to be reasonable as to duration, the scope, and the prohibited activities, and we'll talk about that in a second. So this is most of the time the question I get, the counseling I give on non-competes, and employers say, well, geez, I can't bind this level of my workforce with a non-compete. And I think they're thinking about the presumption, or at least in concept, what the presumption is. And the presumption under 2704 is that only the top 5% of your W-2 wage earners are presumed to be key employees. And most of the time, that's what you're talking about, your high-level sales folks, your C-suite employees. And I think under the Idaho Code, as a presumption, they are key employees. But if you look at 2702, this is the definition. Those employees, by reason of the employer's investment of, and investment of what? Time, you're taking time to educate them. Money, you've invested in them in seminars, in building up their knowledge in the industry, trust of the employer, exposure to business, your intellectual property, your business plans. They have a password that they can go in and they can see your financials. They can see your next greatest best product. They can see your secret sauce. And if by reason of the employer's investment, an employee has gained a high level of inside knowledge, and if they use that inside knowledge, they have the ability to harm or threaten your employer's legitimate business interests, they're a key employee. And I've argued this a number of times to courts, and not C-suite, not primary level manager, not even another manager, but another employee, four levels down the organization, and we've enforced non-competes against them. And there was a good reason to do so, because that employee knew the secret sauce of the company and was hired by a direct competitor. And we were able, it's a little draconian, but we were able to get the court to say, absolutely not, employee. You signed an agreement that says you wouldn't go work for a direct employer. Other basics, when I talked about duration, the statute provides for, it's presumed that 18 months is reasonable. Most non-competes I see, you want to be fair to your employees if they leave too. So I normally see 12 months or 18 months. I don't see many non-competes go beyond that. And the only way that you could have an enforceable non-compete beyond 18 months would be as if you provided some additional consideration. In Idaho, continued employment is sufficient consideration, which means, hey, employee, if you want to work here, you need to sign this document. That's sufficient consideration. A number of other jurisdictions say you must give some kind of bonus. Idaho doesn't say that, but if you want to have a non-compete longer than 18 months, then you need to give some kind of bonus or additional consideration. And it shouldn't be nominal. It shouldn't be $500. It should be pretty substantial. I'm thinking 5 figures or something like that. Restricted to the geographic area in which the individual provided services or had significant influence. And this means you're a nationwide company, you're based here in Idaho, you have an employee who was your Northwest sales representative and knew your business plans, your financials, and your customer contacts. And if you try to restrict that employee from working in the entire United States, a court's likely going to say no. So you want to draft your non-compete to be specific where that employee could actually damage your legitimate business interests. And that would be in the Pacific Northwest, or where that employee actually touched when he was employed by you. The type or line of business, what they're trying to cover, what the legislature is looking to cover here is if you have, let's say you have an employee who serves your business in the healthcare space. And then you have on the other side of your business, you maybe have hospitality. And this person was involved exclusively in the healthcare space. You're not going to be able to draft an enforceable non-compete that says that person can't work in any kind of sector for another employee. So you want to be specific to the line of business your employees working in. When introduce non-competes or modify non-compete agreements, I deal with this pretty frequently. You have sophisticated employers that want to protect their confidential and proprietary information. And basically, anytime someone new comes into the door into a position that's a key position, they're about to give you a whole bunch of information that you could damage the company with if you went to another employer, that it's a condition of employment for a new employee, onboarding paperwork, you get them a non-compete agreement and they sign it. If they don't want to sign it, you don't want to have them as your employee. The harder one is existing employees. Some employers, as they're growing in size, maybe they started as a startup and now they've got 50, 80 employees, and they realize that there's some other competitors they're trying to take, trying to pick off some of their talent. You may want to get those employees under a non-compete, and it's sufficient to provide continued employment. Employee, you've been with me for 3 years. If you want to stay employed here, you need to sign this document. Oftentimes, an employee will say, well, I got other options out there. I'm not going to sign this. Then the employer has to make a difficult decision whether you terminate that employee or whether you allow that employee to continue employed and not sign the agreement, or whether potentially there's some kind of incentive. You could provide them some kind of severance pay if they were to leave. You could provide them some kind of promotion. That's another great time to have an employee under a non-compete. You're a VP, we're making executive VP. Now is the time to sign, or you're going to provide raises in the organization. And right now, with the market the way that it is, it seems like a lot of employers are having to increase compensation. So if you're going to do that, we'll increase your compensation, but you need to enter into a non-compete agreement. And you need to explain to them, this isn't to prohibit you from working and from earning a living. This is to protect your employer and to protect this employer who's providing you compensation to be able to protect itself in the marketplace. So we're not losing out to our competition unfairly. So the drafting checklist, we talked about the basics. I read some really horrible non-compete agreements. I'm not sure who drafted them. Maybe they were on legal.com or something and someone pulled off a form, but it's generic language. Employees shall not engage in activities similar to those performed while employed by the company. That's not helpful because there's so many fact questions there about, well, what did the employee do while they were there? and it's not going to be something that you're going to be able to run into a court and enforce. Blue pencil clause, 2703 does provide for blue penciling. And again, that's reducing the restriction down to something reasonable to protect the business's legitimate interests. But I think it's appropriate to have language in the agreement itself that the employee acknowledges that the employer or that a court or an arbitrator would have the ability to do so. Consent for injunctive relief is another important one. If you have a non-compete in place, and a lot of the times you may have an employment agreement that has an arbitration provision. You have the point where you're forced to go to arbitration, but to get the arbitrator on board and to agree to an arbitrator, you may be 30, 60, whatever days down the line, and the damage to your company is already going to happen. The goal of having a non-compete in place is that you can hire a lawyer with sweat on their brow 24 hours after contacting them, run into a district court and say, I need to be heard today. This employee has the ability to damage my company and you need to make them stop. And you need to have that language in the non-compete agreement so you can go in there and get that relief. Either a carve out from an arbitration provision or just some language in there to allow you to go get that immediate relief. A lot of employers have employees that practice in or that work in a number of states. And if you're not clear on what law is going to govern, then you have an employee that works in Idaho, Washington, and Oregon. Oregon's laws are much more onerous than Idaho's laws are. So if you have an employee that's primarily based in Idaho, you want to be very clear that Idaho law applies. A couple other things, you want to authorize the company, the employer, to be able to provide notice to customers or to future employers. And I've had instances where this language didn't exist in a non-compete agreement. You have an employee that leaves and the employer sends a copy of the agreement to the new employer with a demand letter that says you shouldn't be hiring this person. Well, that former employer has then had either counterclaims or claims against them for tortious interference with contract or prospective business advantage, because that employer is taking an aggressive position and said you shouldn't have. The employee takes an aggressive position and says, you didn't have my authorization to send that agreement, which was a confidential agreement, to my new employer. So make it clear, hey, if you leave here, we can take this contract and we can provide it to customers that we think you're going to pick off and let them know, hey, you can't go with that employee, or to the new employer. And then you can also require the employee to give notice to the former employer, to you, during the restricted period, that 12 or 18 months, that says, hey, if you take a new job and you get new duties, you need to tell us what they are so we can make sure that we can enforce your obligations to us. Suing to enforce, what can you expect? An injunction restraining order generally ends these cases. You either win or lose on the injunction. You can proceed forward with a lawsuit based on lost profits if you don't restrain that employee, and that's potentially, as I said down here, how long does it take? That could take 12 months, 16 months, and that can be a big burden. So you're going to win or lose likely on the injunction. At the end of the day, if you did have to go all the way through litigation, there's going to be a basis for you to recover your fees and costs under the Idaho Code, and also you should have something drafted in the non-compete agreement that allows the prevailing party to recover fees and costs. A lawsuit can be expensive. If you go through the injunction route, it's basically a mini trial 2 weeks into a lawsuit. And I've had 2-day, 3-day, 4-day, 5-day hearings where there's witnesses put on, and it's like a trial. And that it can be expensive. You can spend $30,000, $40,000, $50,000, $60,000 out the gate. But if you protect your confidential information and you're not losing your biggest customers, that may be a spend that you're willing to make. But if you don't have a non-compete in place, you don't have that option. If you're going to enforce a non-compete, you need to have your house clean. If you have an employee that is leaving and they've been a whistleblower, hey, our accounting department's cheating, we're billing Medicare and we shouldn't be doing that, some of those issues, then they're going to have a counterclaim, and that's going to impact your ability to enforce. The same with a wage claim. If you had an employee who earns a bonus in Q2, but you don't pay the bonus until midway Q3, but you don't have a clear policy that says they haven't earned that bonus unless they stay an employee in good standing all the way through the date of payment, that can create a counterclaim, and that's going to impact your ability to enforce. Misclassification of exempt, non-exempt employees, misclassification of contractor, other discrimination, hostile work environment things. You need to have your handbook and policies in place and have a clean house in order and able to have effective non-compete. So whether to use it or not, if you don't have one, an employer leaves and you want to send a demand letter, you're going to have some very, what am I trying to say? Smoking gun evidence, right? You're going to have something where the employee sent to their Google account some kind of confidential information that you think they're going to use, because you're not going to have a way to run into court and to stop the employee from working there. I think it's best practice, if you are in a jurisdiction that allows a non-compete, have them in place. If you want to waive them and allow the employee to go work, that's your prerogative later if you want to allow that employee to work for a competitor. But if you don't have a non-compete in place, it's a much more complicated demand process and a much more complicated litigation process. Finally, if you're hiring employees with non-competes, they may not tell you. You post a job, you get someone that comes in and applies, they look like just a stellar employee for you. They've got all these contacts in the industry, and they're going to take you from this level to that level. You hire him and bring him in, and later you find out, because you get a demand letter from the former employer, this person's under non-competes, they can't work for you. You as the employer are going to be on the hook for tortious interference claims, and under the respondent superior doctrine, that the actions, unlawful actions that your employee took, you're going to be on the hook for. So if you hire a new employee, either in an employment agreement or in an offer letter, have them acknowledge, I am under no restrictive covenants from any former employer, and I will not use any confidential information from my former employer. That way you insulate yourself from any claims of a former employer who do have the deep pockets to come after you and engage you in protracted litigation. So I think I got done with about 2 minutes to spare. If you guys have any questions on non-competes, trade secrets, restrictive covenants, or some COVID items, I'm happy to answer any of those questions.
Thank you, Dean. We appreciate your time, and that was very thorough. So that was really good information for us. So yeah, as he said, if anyone has any questions on any of these topics, or probably any other topic that relates to employment law, or if you had a specific situation at your business that you want to bring up.
And some of those are confidential, and I understand it. And if you don't want to present it in front of everyone here, if you want to give me a call, that's my direct dial, or shoot me an email. I'm happy to walk it through with you.
Thank you, Dean. Questions? And if not, that is okay. Like I said, Dean, that was really great, really thorough. I appreciate it. And our businesses will too.
Well, great. Happy to be here.
Okay. Well, thank you everyone for joining. And like we said, we will post this on our Commerce website for anyone to watch at a later time.
Thanks,
Okay,
everybody.
thank you. Have a great